Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, just outside of Fort Worth. Today's short video is about qualified domestic relations orders, or QDROs, and uncontested divorces. I help a lot of clients with both uncontested divorces and QDROs. A question I get fairly frequently in uncontested divorces is whether my client is allowed to use a QDRO even though the divorce is uncontested. And the answer there is yes. A QDRO can certainly be used in an uncontested divorce. And we'll talk a little about what both of those subjects mean, both an uncontested divorce and a QDRO, and why some people think maybe there's a problem using a QDRO in an uncontested divorce, and why that's not going to be a problem. An uncontested divorce is just a divorce where the parties have agreed on the terms of the divorce rather than choosing to litigate the issues through lawyers or following some other expensive process. In this path, whether it's an uncontested divorce or some people call them no contest divorces, there's nothing magical about that phrase. It just means a divorce where the parties are not contesting the issues or spending a lot of money trying to fight through the courts or arbitration or mediation to reach an agreement about their divorce, or taking it to trial and having a judge make a decision. There's plenty of information on my website. There'll be a link below in the description for this video, as well as some of the other videos on this channel that explain uncontested divorce in greater detail. If that's something you're interested in, I certainly encourage you to take a look at those resources. A QDRO, or a Qualified Domestic Relations Order, is a special kind of court order that follows a divorce and orders the plan administrator for an employer's retirement plan to divide one person's retirement benefit and give a portion of it to the former spouse or some other party. The reason why this special kind of order is required is because employer retirement benefits are covered under, most commonly, if they're private plans, ERISA, which is the Employee Retirement Income Security Act of 1974, which has special provisions that prevents plan administrators from just giving away parts of somebody's benefit to another party. Other types of retirement plans offered by employers might include plans covered by other federal laws like military plans, or local government plans, which are covered by state laws but still may require these kind of orders just to allow some consistency in the process of requesting a division of a retirement benefit under their plan. Under a QDRO, there's really only one person that receives benefits under the order. In extremely rare circumstances, somebody else can receive a benefit. Normally, the person receiving a share of the benefit under this QDRO is going to be the spouse or the ex-spouse. And a QDRO is going to make a division of the retirement benefit in two situations, and that's going to explain why the spouse is the most common recipient. The first is a QDRO can be used to divide the retirement benefit in terms of a property division in a divorce. So the house gets divided, one person gets it, the cars get divided, the retirement benefits will also get divided, and maybe it's divided 50-50. Well, the only way to get that 50% turned over to the spouse who's not the employee is through this QDRO that's going to split it up and create that benefit under the plan within that spouse's or ex-spouse's name. The other way a QDRO can be used to award part of a retirement benefit is when that QDRO is following a child support obligation, in which case one parent is the employee who has the retirement benefit, the other parent who receives child support can request the court to order a QDRO that pays out the child support from the retirement benefit, as opposed to maybe income withholding from paychecks or liquidating some other asset. These are far more unusual within family courts, at least here in Texas. Normally, courts only order them when there's an arrearage of child support where some amount has gone on unpaid, and the retirement benefit can be tapped as a resource to get the child support obligation caught up. Commonly, the parent receiving child support is going to again be the ex-spouse. So those are the two situations where the ex-spouse tends to be the recipient of that divided benefit under the QDRO. Now, in some situations, somebody can receive child support who is not a former spouse of the obligor, the person paying child support. And this happens when children are born out of wedlock, which isn't too uncommon these days. In those cases, the other parent, who is not a former spouse, can also request that QDRO to receive child support through that retirement benefit, whether it's a 401k or a defined benefit pension or some other type of retirement benefit out there. The use of a QDRO really has no bearing upon whether the underlying order was contested or not. In the case of a divorce where there's a property division, it makes no difference whether the division that's ordered in the divorce decree came out of a contested court hearing or it was something that the parties agreed to in an uncontested divorce. Similarly, there could be custody cases, whether they're attached to a divorce or separate on their own, in which a QDRO can be ordered to satisfy whatever child support obligation has been ordered in that underlying custody order. When there's a QDRO, there has to be some sort of underlying order that orders payment of either a property division or child support out of the retirement benefit. That order applies to the parties of the lawsuit. The QDRO itself is a separate order that is directed to the plan administrator rather than one of the parties in the actual lawsuit. That's kind of unusual. In most lawsuits, the court cannot order a third party to do or not do something as a result of whatever the outcome of the lawsuit is, because everybody has due process rights to be heard and give notice of claims before a court can order some sort of action or restrict action on that party's part. QDRO is a special carve-out that exists both in those federal laws and state laws that govern retirement benefits, as well as the Texas Family Code and the family laws of every other state in the country. So some people seem to think that QDROs and other types of specific property division or child support orders cannot be used unless the court has a trial on the merits and orders the child support or property division that way. And that's simply not true. Any remedy that's available in a contested hearing is available in an uncontested case, whether it's a QDRO or some other type of order. There's nothing within the Texas Family Code that requires the court to hold a hearing before certain remedies can be ordered, at least as far as a final hearing goes, or a final order is issued, whether that's a custody order or a divorce decree. The QDRO itself is sort of a post-final order that issues something to ensure that whatever is in that divorce decree or custody order is given some teeth and can actually be executed the way that the underlying order has required of the parties. So that's basically the issue. If you've got some other questions about uncontested divorces or QDROs, there's plenty of information available on my website. There's a blog that has several posts that discuss both subjects. There's some other videos on this channel. And of course, if you're in Texas, specifically in the Dallas-Fort Worth, North Texas area, I'm happy to discuss those issues. If you have an uncontested divorce or a QDRO that needs to be completed, you should certainly talk to an attorney about those issues and the best way to get that done.